Ladies and gentlemen, welcome. My name is Wes Riss. I am the Deputy Executive Director here at the American Society of International Law. We want to thank you all for joining us this Monday afternoon, especially with the threat of rain coming. But we're very excited to be able to be in the second of our three-part series with the American University Washington College of Law and the Academy on Human Rights and Humanitarian Law. This is a series that we've done now for at least 6 years, I believe, and it's been incredibly successful. They've taken advantage of the wonderful speakers that they've brought in from all over the world to train and educate their students at their summer academy program. And ASIL is very thrilled to be able to host these programs at Tiller House during that time. For those of you who don't know, the Society is a 111-year-old professional membership association. We started off as just a collection of international lawyers, but now we expand quite far beyond that in interdisciplinary ways with political scientists and environmentalists and political theorists involved as well. The Society actually has 40% of our members outside of the United States, so even though it says American in the title, we are a very international body. And our members are very focused on a wide variety of activities. So we have 35 different interest groups, some of which are geographic in nature and focused on particular regions of the world, some of which are demographic in nature and focus on minorities or women or new professionals in international law. But the vast majority of which are focused on different substantive areas of international law, whether that be the law of armed conflict or law of technology, space law, law of the sea, human rights, private international law, just about any topic you can think of. We have a collection of our members who are not only interested in that, but are working in and promoting activities related to that, whether they be public engagement and education events, opportunities to present papers and do academic study on those things, or working with students and new professionals to help encourage them to pursue those careers. One of those interest groups is the International Criminal Law Interest Group, especially relevant today, given our speaker. So if you're interested in finding out more about this particular topic, or in getting involved in the Society in a particular way, please feel free to come to talk to anyone wearing an ASIL name badge from the Society afterwards, and we'd be happy to give you more information on that. That said, I want to turn things over to Diego from American University and then get things off to our panelists very quickly. So Diego.
Thank you very much, Wes. Well, welcome everyone. My name is Diego Rodriguez Pinzon, co-director of the Academy of Human Rights and Humanitarian Law with my colleague Claudia Martin. And we, as you very well said, we have been doing this for now 6 years, which is a complete tradition in Washington, D.C. And now yes, we are very excited to continue with this initiative. This is part or result of an effort that we've been carrying now close to 20 years, it's going to be 18 years of a summer program in which we bring close to 40 faculty that join the faculty of the IOCL to produce a good number of courses during 3 weeks. And it's part also of our LLM in Human Rights and Humanitarian Law in the law school. So we are delighted to be able to continue to host these events and look forward to do it in the future. We are delighted here to have, a privileged panel of speakers. Professor Orentlicher, want to thank you very much for being here. Professor Orentlicher is faculty in our law school. She's an expert, world-renowned in many of these issues related to transitional justice, impunity, and so forth. I could stay here. You have the bios in the leaflet from Diane, and again, we are delighted to have you here as a discussant of our guest. So I think you will be introducing then Judge Fernández de Gurmendi. And again, thank you very much for everyone to be here. Hope you enjoy the discussion. Thank you very much.
Thank you. Can everybody hear me? So I'm delighted to add my own welcome to all of you to a very special program, a conversation with the Honorable Silvia Fernández de Gurmendi. And as everybody here knows, Judge Fernández is president of the International Criminal Court, or ICC. She has also been a judge on the court since 2011. Didn't get that right this time. She brings brought to that position a wealth of experience and expertise in international law, as well as diplomacy, which is an important skill for the president of an international tribunal in ways that are unfamiliar to domestic heads of courts. Among her many past achievements, Judge Fernández served as Director General for Human Rights at the Foreign Ministry of her native Argentina. And I believe it was in that capacity that she became a key participant in deliberations that ultimately produced the statute of the International Criminal Court. She later spent 4 years working in the office of the prosecutor of the ICC before returning to Argentina and then coming back to The Hague. When Judge Fernández was elected to the presidency of the ICC 2 years ago, my colleague Kelly Askin very aptly recognized what her leadership would mean for the court. Ms. Askin noted that, quote, strong judicial leadership is indispensable in building a sustainable, credible court, end quote, and hailed Judge Fernández's outstanding qualifications to provide exactly that kind of leadership. So this evening, we'll have a chance to explore with Judge Fernández how she has used her presidency so far to advance the ICC's core goals. The format's going to be as follows. I'm going to kick off our discussion impersonating Charlie Rose and asking Judge Fernández a few questions about her own vision for the court, her sense of the challenges it faces, the opportunities it's now facing, and what it will take for the ICC to meet those challenges and seize the opportunities ahead. And then I'm going to open the floor to questions from the rest of you. So let's begin. And first, let me invite you to join me in extending a very warm welcome to Judge Fernández. Thank you for being here. So I want to start by asking you about your own vision for the principal goals of the court. As you know better than anybody, scholars and victims and others have ascribed a really broad range of goals to international criminal tribunals. You know, they will deter future atrocities, they will provide justice for victims, they will be centers for norm diffusion, affirm the importance of certain core values for the whole world, catalyze domestic prosecutions, and so on. While many people have huge expectations of the International Criminal Court, we probably don't have anything like a consensus about what its primary goals should be. So I'd like to begin just by asking you to say a bit about your sense of what the core mission or missions of the ICC is.
Well, thank you very much. And first of all, I would like to thank you for inviting me to be part of this dialogue this afternoon. I am very happy to be part of this tradition. I hope I will not spoil the tradition and that you will continue after my this afternoon. I am really very, very happy to be able to have this conversation with you. You have asked me what do I believe the goals of the court are, and you also mentioned the expectations of others. And this is indeed something that has been, in a way, a huge challenge for the court in itself, is to how to manage the huge expectations that the establishment of the court raised in the international community. As you know, the establishment, the creation of the court was in itself a huge achievement. And at that point, actually, the major goal was to create this court. That the creation of the court in itself was considered to be a huge a step forward in the fight against impunity for international crimes. Then, when finally and there were some questions on whether this would be possible at all, and even in the final hours of the Rome Conference, there were questions on whether the treaty would be adopted. And when it was adopted, there was incredible happiness and cheer, and everybody was so cheerful. But of course, then the second question arose was, well, is this treaty going to enter into force one day? And only 4 years later, the treaty entered into force, achieved the number of ratifications that were required, which was quite high, actually went beyond that. And then the question was, well, but is it going to have any kind of operations, any kind of real work in real terms? And then eventually the court was established in The Hague. If the judges were elected, the first prosecutor was selected. And remember, at the time, the prosecutor defined what would be success for the court, which was, and he said at the time, well, this is a court of last resort. It's a court that is complementary to national jurisdictions. The duty of investigating this type of atrocity crimes lies on states. So in a way, he said, success for the court would be that there is no case before our court because the states are doing their work. In fact, we have cases, and some regret now that we don't have enough cases. And I think that at this point in time, what we can say is that the court has achieved not only to be created and exist, this existential goal was achieved, but it has started operations. And I think in the medium and long term, now the huge challenge for the court is to maintain relevance. And when I say that, means that what is relevance and what is the success for the court is the concept of accountability. I think it is well established. This is a huge achievement of the last 3 decades. And this is here, and this is here to stay. But the court was created as a permanent, it's the only permanent general court. So it has a central role to play in ensuring accountability for these type of crimes. So it is important that the court is perceived, because when we're talking about success, about goals, we're talking about realities, and we're talking about perceptions. It is important that the court is perceived as an institution that can address these type of atrocity crimes for which it was created. It is the worst thing that could happen to the court is that it's marginalized, that the court becomes irrelevant because either it has no jurisdiction over certain situations that are of extreme importance to the international community, that it has no cooperation when it has jurisdiction to deal with the situation, and then it cannot proceed, or finally, whether it cannot deliver justice of high quality. And that is related to the efficiency of the court. So as president of the court, I have been trying, and maybe we can develop this further, I have been trying to tackle these 3 challenges to relevance. I would say, or three goals to success, if you want. First, universality. The court has the treaty has 124 states parties. We need to enhance the participation in the treaty because without participation, the court cannot address all situations equally. And that ends up affecting the legitimacy of the institution and its efficiency and effectiveness. Second, we need to obtain sufficient cooperation for the situations that are being addressed by the court. And third, last but not least, we need to enhance the efficiency of the institution. We need to expedite proceedings. We need to prove that we can deliver. So these have been my goals, and we have done a number of things towards those goals. Thank you.
Thank you. You said several things I'd love to follow up on. I want to begin where you left off on the question of efficiency. So I know that a very high priority of your leadership has been improving the efficiency of the ICC streamlining procedures. And which makes a lot of sense for the reasons you already indicated. As I mentioned to you, I'm finishing up a book I've been working on for a long time on the impact of the International Criminal Tribunal. And one of the principal disappointments that victims have is how long the proceedings take. And it's really been a frustration for a long time for victims. But one of the things that has become increasingly clear as the life of that tribunal has extended over time is that just the cumulative weight of time affects the quality of justice for victims. So kind of with that background, I'd love to hear more about how you've tackled this question, what your sense of is, what's your sense of how well that's going, but also what are the challenges for you in unwinding procedures that became pretty complicated and kind of sometimes seemed really tied up during the first decade of the ICC's life? I mean, how do you unwind procedures that you might not have designed as such, and maybe they came out of a particular context that's no longer so relevant, but now you've got them?
Well, indeed, proceedings at the International Criminal Court are perceived as being too long. And I think, and you mentioned other tribunals, and that has always also been the criticism. And indeed, the proceedings take a very long time, in particular for victims, because the proceedings are not just the time that you you count in the courtroom. The victims start being approached by the office of the prosecutor years before that. So there is this expectation that is being created already at the investigation phase, or even before the investigation, at the preliminary examination. So it may be years before the prosecutor takes the case to the judges, and then the judges will need to deal with these proceedings. And in the case of the ICC, the proceedings indeed are extremely complicated, and I will come back to that. So yes, it can be years until you have an outcome. And I was in Uganda this year in February. I went to visit some of the localities where some of the massacres that are being now tried at the court took place in Gulu, Lukodi, that is northern Uganda. And that was the question of all victims. And, this is a particular case because it's the first case of the court. And I said one of the case against this Ugandan individual is probably one of the first arrest warrants that were issued by the ICC. Dominic Onwen, the person that is now being tried, he was at large for 10 years. He could not be arrested for 10 years. So this is not the fault of the court. But this man at large for 10 years, we could not start the trial. We don't have trials in absentia. So when I went to Gulu to see the victims and to see some of the projects that were being developed to address the harm suffered by victims by the Trust Fund for Victims, the main question is, well, we have been waiting here for more than 10 years. When is the case going to finish? And I said, but the case started 2 months ago. Well, not for them. For them, it started 10 years ago. So this is a very real and concrete issue. And for them, it may be a source of finally losing any hope or any trust in international criminal justice. So some of it we can address, some of it we can't. Because I already mentioned 10 years waiting for the person to be arrested. This is something that is really not within the powers of the court to address. But we can address everything else. And we should be able to finish this trial very quickly. Now, that goes into the second part, which is what we do and what we have done in order to address these very complicated procedures at the ICC. And unfortunately, I was involved in their drafting. So I cannot say that is the blame, or I put the blame on others, because I was really very much involved in this. But I don't think there is necessarily something very wrong with the procedures themselves. But indeed, they were difficult to understand for those who had not been involved. And for the first 10 years of the court, indeed, there were several responses that were given by the judges of different chambers in different directions. And the accumulated result was something extremely convoluted with a lot of litigation around nothing, because in some cases there was not even suspect yet there, but there was a lot of written agitation and a lot of work. So we need to unwind. Well, as I said from day one, this is something that you cannot do on your own, because also judges sit in different chambers. Judges are independent. So I cannot, as president of the court, decide, well, this is the way you will do it. So what we did is to try to, for the first time in more than a decade, is to sit the judges around a table to have an in-depth discussion of procedures. I had some documents prepared with all the jurisprudence that had been developed by the court. We went with the judges to a retreat a few months after I started as president with the new judges that have been appointed to the court. We went to a retreat that actually took place in Nuremberg. We had a retreat in room 600 with the Nuremberg trial had taken place, with the hope that history would also inspire us. And actually, we had an incredibly good session. We really identified some of the problems. We identified some of the solutions. And at the time, the main problem was indeed in the preliminary, the pre-trial phase and the transition to trial. We reached some agreements on some of the issues, and we reflected those solutions in a chamber's manual. So it is not a binding document. It is not an amendment to the procedures. We try to avoid proposing amendments. We try to do it through harmonizing practices. And we are implementing these agreements. And I have to say that the result was quite spectacular. From, let's say, the first case, in the pre-trial phase, from the confirmation of charges to the commencement of the trial, the first case, Lubanga, was 22 months. In the last case, Onwen, which is far more complicated with 70 charges, it was half, to 11 months. And also in circumstances very difficult, because we needed to give some time to the prosecutor to update the evidence after 10 years of being at large. So I just give you one example. Of course, there are others, but we really managed to have a very concrete impact. And that was, and also we tried to identify better solutions to the victims' participation and the victims' applications. We harmonized, we also had some amendments were proposed in order to expedite interviewing, the interview of witnesses, for instance, and we have managed to also reduce by 50% the time that is spent per witness in the courtroom. So we have, together, we have provided some solutions in order to unwind 12 years of very diverse solutions. Then we had a second retreat to deal with trial issues. And now we are having a third retreat in 2 weeks to deal with appeals issues. So I'm not saying that this will solve things. This is not magic, but it is producing huge results. And what is important is that now there is this general recognition that we need to really discuss together the way forward, that there is no single solution that can be used by one chamber, that we really need to try to improve in this regard. Something that seems obvious today, but you have to think that when I arrived at the court in 2011, judges of different chambers would refuse to discuss matters, thinking that that would affect the independence. So I think it's a huge different approach, change in the approach and attitude.
Did you talk about any of that when you went to Uganda? When you went to northern Uganda, did you discuss with victims what you're trying to do to expedite proceedings so that they don't have to wait so long? I'm curious how you link what it's like being the president of a judicial chamber with people on the ground thousands of miles away waiting for justice.
Well, I have to Of course, I did explain to them that we recognize that they've been waiting for very long. And some of them actually had very concrete procedural questions. So I tried to answer these questions. I could, without lying, I could assure them that everything will be done in that case to expedite the proceedings, and I know that it is being done. So I think it is going to be as expeditious as you can get. But of course, you cannot erase 10 years of expectations. Right. So that is something that is very difficult. What we are trying to do is a huge effort also for them to follow the proceedings in situ. And when the trial started in December last year, we put several projection centers in different places, different localities. So the victims, the local communities can really follow live the proceedings in The Hague. The registrar, instead of being at the courtroom the day of the starting of the trial, was in Gulu explaining to the victims what was being done. And that was highly appreciated. And actually they continue to follow the proceedings very much. And of course, this was a joint visit with the Trust Fund for Victims. So the victims are very much interested in what happens in the courtroom, but of course they are also very interested in what happens with relation to the projects that are being implemented to help them in the harm they have suffered. And there is a huge appreciation for these projects.
One of the things I wanted to ask you to talk about, and not just because I'm writing a book on the subject, was whether you had there were lessons learned from the experience of the ICTY and ICTR and other tribunals that were created before or around the same time you began operating. So as you were talking, I was thinking back on some of the experiences and learning by doing that the ICTY and ICTR had in terms of outreach, and which I guess is sort of the jargon for just communicating with local communities that give rise to cases before the ICC. So while you were talking, I was wondering when you saw some of the questions that victims asked, helped you understand how little they understood about the procedures or the fact that the defendant wasn't in custody until recently. Did you think, gosh, I've got to go back and make sure that we do more regular outreach? In other ways, have the kind of programs you mentioned, the in situ projection, been lessons learned from the experience, or was it just sort of obvious that this was important?
No, I think there is, of course, everything is part, it takes into account lessons learned. Lessons learned from other tribunals, but also lessons learned from ourselves, because already after 15 years, this year we are celebrating 50 years of entry into force, so let's say 14 years of operations. So we are already also taking into account the lessons learned in our own court. And so we have learned, and we have improved. So I think we take into account very seriously the importance of outreach, which was important for our tribunals and also for our court. There is a limit. There is a limit on what we can do. Sorry. There is a limit of what we can do in terms of the resources we have. The resources that we have for outreach and external relations are limited. So we use every opportunity, but there is a limitation there. To answer your question, yes, lessons learned are important. And I think, as I said, the court is 15 years old, but international criminal justice is now what, 30 years old? So I think we have learned a lot in the process, and I think we are applying that.
Turn for a minute to, I wish I could offer you a cough drop, to sort of some of the challenges to which you alluded earlier. So the most obvious one, or the one that receives the most attention anyway in the press, are challenges posed by some African countries and by the African Union. I think everybody's familiar with those generally. So last year, 3 countries announced they were going to withdraw from the court. One of them, the Gambia, fortunately reversed that decision after a new president was elected. Another, South Africa, at least for now, has put a brake on that process as a result of a decision of its high court, I think in February. And in the meantime, some others are, Burundi, I think, is still moving forward, and others have indicated they may contemplate withdrawing. In one case, Namibia, I believe, unless the United States becomes a party to the ICC. As it has an ironic sense of humor, I suppose. And the African Union for years has been, as you know, concerned about the focus on African countries in the docket of the International Criminal Court. At its most recent summit, it adopted, I gather, a draft strategy with a number of heads of state expressing reservations to it, calling for at least a strategy for a collective withdrawal of African countries. So in light of all those challenges, it would be, first I'd like to get your assessment of where the ICC stands in addressing those challenges. And then as a sort of related question, I understand that you have embraced the notion of dialogue with countries that have concerns about the court, and hope that that way of engaging with critics can be more productive in addressing their concerns and keeping them as part of the ICC family. So I'd also like to hear what that means in practice. I mean, how do you negotiate with countries that are considering withdrawing? What's up for negotiation? Is there a way to, is there in practical terms, a way to address their concerns about arrest warrants against sitting heads of state? How do you go about addressing that? So first, your sort of general sense of where you are in meeting those challenges, and then maybe we could drill down on the process for addressing them.
Thank you for these easy questions. First, in general terms, the challenges, and in particular the challenges in Africa, where it is not surprising that most of the frictions are there, not the only there, but most of them, because most of the situations of that are being addressed by the court were opened in Africa. Of course, the majority of these situations were referred to the court by the African states concerned, but regardless of this, it is indeed the continent that has focused the attention of the court, and thus has created some issues. I have to say that the more than 60% of the African continent is now party to the Rome Statute. So there is a vast majority of African states that are parties to the treaty. The African Union is the entire continent, so there are a number of countries there that are not parties to the treaty. So some African parties to the Rome Statute have raised the concern that the ICC should not be subject to an analysis or consideration by the organization, because this is many of them are not parties. In any case, I have to say that the African states individually have provided a huge amount of cooperation to the court. And the investigations that are being carried out, the proceedings that are being conducted, all this is possible because of the support that we receive from African states. And even states that have been expressing concerns about the court, they continue to cooperate with the institution in the field. So the situation should not be perceived as a crisis between the court and Africa on the other end, because this is not real, this is not the reality. Now, in the individual states not only cooperate with the court, but they actually, when they come to the Assembly of State Parties, where the parties gather, the majority of them express very positive views on with relation to the court, and they come with high-level delegations. So their relation with Africa is good in that regard. Now, the African Union has issued some resolutions against the court. And as you said, 3 countries announced their intention to withdraw from the ICC. This was a particular crisis last year, in October last year, when 3 countries announced their intention to withdraw: South Africa, Burundi, and the Gambia. And actually, that was a few days before I had to go to report to the General Assembly of the United Nations. And every time, and I didn't know what to expect, because I took the plane with these 3 withdrawals behind me. And when the general debate started and countries were adding their names to the list, you didn't know whether they would speak to say that they were also withdrawing, because they were all kind of rumors. Actually, when I came into the room, some asked me whether Argentina was going to withdraw. So, oh my God. So actually, the debate went very, very well. States that I thought could be against the court actually spoke up in favor of the court. And a few months later, we had the Gambia and South Africa that, for different reasons, withdrew the withdrawals. And I have to say that the expression of support for the court when there were these 3 withdrawals was so impressive, and that actually it raised the profile of the court in a very positive way, because and actually even in the African Union, many African states that normally would not speak up, they spoke up in favor of the court. There was these announcements of a withdrawal strategy, but actually there was not such a thing. The documents that came out of the meeting show that there is no real strategy to withdraw. Actually, there are a lot of declarations in favor of the court. So I would say that the situation, if there was a crisis, that was already the starting of a new relation, much, much more positive. Now, indeed, during these events, many of us, and I did it myself, spoke about the importance of a dialogue. The president of the Assembly of State Parties, who is the Minister of Justice of Senegal, he also spoke about dialogue. But also myself, as a judge and as a president of the court, I also spoke about dialogue. Now, a dialogue between whom and to do what? The court cannot engage in negotiations. The negotiations are for states among themselves, but the court cannot enter into negotiations on the law. We cannot negotiate the arrest warrants. We cannot negotiate the application of a provision, but we can listen to concerns, and we can explain ourselves better, because the court has been accused of being arrogant, of not listening to others, protecting themselves beyond the shield of independence or judicial independence, and not listening to the problems. So that, I think, we need to do. So dialogue, for a court, is basically a process of listening to concerns and showing and trying to explain first showing that you really listen and that you understand what is being said, and explaining the limitations of the court and the reasons of the court. Now, this dialogue can take many forms. As president of the court, I engaged myself in this dialogue, and actually I've been doing this for 3 years. It's not that I started one day because of the withdrawals, but with the withdrawals, I really try to do more. And this dialogue is not only with governments, but also with civil society, with the NGOs, with the legal profession. We try to engage in a dialogue with the bars associations, with associations of defense counsel, with judges, with prosecutors, with the global community at large, and also with governments. For instance, when I went to Uganda, I did try to see the president of Uganda, who had been particularly hostile to the court, I would say, and we had a meeting and we had a dialogue. And he appreciated this concept of dialogue because he said, indeed, you are so arrogant. So arrogant, you judges. So I think this is important. Now, also, in the case of South Africa, which was one of the issues that raised the concerns of South Africa, was the arrest warrant of al-Bashir and the alleged non-cooperation by South Africa. So this is something that is a judicial matter, whether the South Africa cooperated or not when it refused to arrest al-Bashir. So this is for the chamber to decide. But again, they are even in a judicial manner. You can enhance the dialogue by requesting submissions, by way of amicus curiae, for instance, from different corners, to address their concerns in a judicial manner to the judges. And that was done. And this is a hearing that took place at the pretrial chamber 2 or 3 months ago, where there were written submissions and there was a hearing. Now, the decision is going to be for the judges to take, but they did listen and did request for presentations and submissions to enhance their analysis. So that is a way that a court can engage in a dialogue without compromising its judicial independence.
Mm-hmm. Thanks. I just want to ask one more question before opening the floor. So one of the core tenets of the Rome Statute is that the court, as you mentioned earlier, is a court of last resort, and Luis Moreno Campo put the point very extremely, as you said earlier, saying the court will be a success if it doesn't have any cases to try. But the court has the capacity to prosecute only realistically a handful of cases at any given time. And unfortunately, there's all kinds of business that is eligible for the court's attention all over the world. So national courts really have a lot of work to do. The court can't do more than a handful of cases. This, to some extent raises the question I asked earlier about, how do you define success, given that the ICC is a court of finite resources? How do you know whether you're making the most of those? So I'll let that just stay out there. If you want to come back to that question, you can. But the question I really wanted to ask now was, so the core concept of the ICC statute that deals with the relationship with national jurisdictions is that of complementarity, which only a lawyer could come up with, right? Complementarity. Say that to a non-lawyer, right? What's their expression? Wait, what? Complementarity. And that, the notion is that ICC will step in only when national courts that have jurisdiction are unable or unwilling genuinely to carry out an investigation or prosecution. There's been so much talk since the court became operational on how to improve complementarity. There's been so much talk and attention to it. And yet it seems like it's really challenging to move the ball forward in actually galvanizing domestic courts to step up to the plate. And I wonder if you have thoughts about how to enhance that particular process. I mean, do we need a new institute for complementarity that will be dedicated to working with national courts on this process? I have a follow-up question, but why don't I let you address that one first?
Thank you. The concept of complementarity is very difficult. I don't know who invented that word.
A lawyer.
Actually, the court is reviving dead languages, and written language, non-written languages need to be interpreted in the courtroom, and now we are trying to deal with this complementarity. Well, indeed, the complementarity, whatever that is, can only function if the national systems do their part. Because the system is based on the principle that the investigation and prosecution of these crimes, of international crimes, are also the duty of states. It's their right, and there was this discussion that the court would not have primacy. It's the right of the states to do this first, but it's also their duty. So that requires, first of all, that states, well, of course, have the will, but if they don't, and that's why the court has been created as a last resort, but it's a backup when the courts, for whatever reasons, don't do it. But when they do want to do it, the issue is that they need to be able to. And that requires legal tools, basically to have the laws to do it, and some national capacity to apply these laws. So many things are needed in order for this to be done. I don't think that this can be done by one single institution. I don't think you can create an institution that deals with national capacity. I think building national capacity, I think by definition, is a decentralized process. Many actors need to help states to build this national capacity. And actually, many entities are doing this. Non-governmental entities, UN entities, for instance, UNDP has a lot of projects in national capacity building. And actually, some NGOs, at the same time that they urge the states to ratify, they also try to urge them to adopt implementing legislation. They give them assistance to adopt implementing legislation. Some regional organizations have developed models on national laws. So there are a lot of things that are being done. But of course, there is a lack, and probably that is something that needs to be done, is to coordinate these efforts and also to galvanize efforts. And I think the court is not cannot do it on its own. There are a lot of questions that are being asked to and a lot of expectations. And I said, Albany come to the court and say, what are you doing to build capacity in Congo? Or what are you doing to help certain states to investigate and prosecute? Well, very little. The court itself can do very little. We do try to provide assistance when asked. We give lectures. We assist in particular, the Office of the Prosecutor is very much in connection with some situation countries, trying to help them in their national proceedings. But the actual work needs to be done by others. So the court can act as a catalyst, can act also in terms of trying to encourage this to be done, because also it's important that the idea of accountability for international crimes is mainstreamed in these many ideas on capacity building. Many of the UN agencies, for instance, UNDP, they do a lot in capacity building in general. So we believe it is very important also to target capacity building for international crimes, because it's not the same to investigate one murder than to investigate complex crimes. So this needs to be mainstream, they need to be understood. And the court can act as an engine for that. It can encourage, it can galvanize, it can act as a catalyst. But I don't think that one single institution could do the job. Unfortunately.
Right. Yeah, I think the question in some ways is really, the real question is there more that the ICC could do? I mean, you answered the question I asked, which was, do we need some other process to step up to the plate, because the ICC can't do it all. But at the same time, I wonder if the ICC could do more to enhance local capacity.
Well, this is a question that has been asked, and actually the state parties said no. The state parties have been extremely clear, and actually there was a Kampala review conference in 2010 where the issue of complementarity and how could the court assist in this was answered by the negative. The state parties consider that it is not within the mandate of the court to engage directly in capacity building exercises. I think we are already doing more than we are supposed to be doing. And they even tried to say that maybe they could do more, but that has not really produced many results. I think we need to live with this idea that we need to focus on our own mandate, which is already quite broad, and then deal with capacity building in the way I'm saying, trying to promote the idea, and we do it. The Office of the Prosecutor in particular does it to a broader extent also, and then encourage others to provide this assistance. There is, and actually, going back to the dialogue, there are some states that there are increasingly more states that are creating war crimes units within their judiciary. So it's not just about there are states that have a lot of capacity otherwise, but they are only starting now to create these units. And actually, we do engage with them a lot, and probably that is a way of also assisting. They come to the court, we go to see them, we exchange experiences, so that is also a way of, as part of our dialogue with the legal professions, with the judges and prosecutors, we also engage in a particular way with those who are working in these war crime units, because they are, of course, they have a lot to learn from us, and we have a lot to learn from them. So it is extremely important to build both capacities.
If it were not exceeding my own mandate, I would be tempted to invite everybody to send their suggestions for 10 things the ICC could do without any additional cost to enhance capacity. I'm just kidding.
No,
I'm not entirely kidding.
Tell me.
Within the mandate. Yeah, it's a great question. Okay, serious invitation. Oh, I just want, you know what? I can come back to my question. Please go ahead. Why don't we open it?
My name is Diane. I'm a lawyer here. I think you're a very brave woman to have this job. And I'm sure there's retaliation against you specifically, Mr. President. Very brave thing you're doing.
Thank you.
Thank you very much. Actually, if I may reply to that, one ambassador said last year when there was these issues of withdrawals, he said, well, dear President, I really have to say that you have an impossible job. And I said, no. I have a difficult job. The one that has an impossible job is the prosecutor. She is a very brave woman. Thank you.
Yeah. Other questions?
Hi, my name is Diane. Thank you very much for a great discussion. And my question for Madam President is, thank you. My question for Madam President is, I would like to hear about your thoughts or the court's position on the admissibility issue of like evidence produced by new technologies such as thermal images, satellite images, or lab reports on the analysis of the weapons used in the prosecution of mass atrocities and human rights abuses. Thank you.
Wow. We love technology. The problem is to understand it. And actually, I am one of the initiatives now that we are pursuing is that we are going to start a series of seminars on evidence. And the first one is on new technologies, because it is absolutely essential to use these technologies. But it is important that not only the prosecutor understands these new technologies and tries to use them, but also defense counsel and the judges and everybody else. So we are trying now at the court to make sure that we are up to the to these technologies by organizing these initiatives to know more about them. You know, the court is really trying to be high-tech, I would say. Actually, the courtrooms are quite amazing if you come to see them. Of course, technology go fast, so probably will be high tech for a few weeks and then will be outdated. But for the time, see, if you are fast, you will still see a highly, I think at this point in time, we are the most advanced court in terms of technology. But already, this is an issue that is being raised, that not all in the courtroom, not all parties and participants are up to this technology. So we need to find the ways of making sure that we all can understand and use these technologies to the best possible way. And there is a huge difference between generations, and also different, depending on where the judges or the parties and participants come from. So we need to make sure that we are all in the same page there.
Thank you, Your Excellency. I join in the comment about our appreciation for your courage. My name is Brian Murphy, and I bellow loudly even without this. Forgive the politically controversial question, but as a U.S. native-born citizen, is there any hope whatsoever that the United States will revisit in a serious way the issue of joining the ICC, please?
Oh, well, thank you very much. But actually, this is a question that I should address you and not you.
Yes.
Well, I have to say that the attitude of the United States vis-a-vis the court has evolved quite a bit in these years. And in the last years, we saw a lot of very positive attitude with a lot of practical cooperation and good will for the court. So at this point in time, if we talk about hope, I do hope that that will be maintained. And of course, in the mid and long-term goal, I do hope that the court will join the Rome Statute. As I said at the beginning of my presentation or my answer to your question, I did address the issue of universality. The Rome Statute needs to be universal. The participation in the treaty needs to be universal because the court has a global mandate that can only be fulfilled if there is more participation in the treaty. We see some situations now that the court cannot address because the parties concerned, the countries concerned, are not parties in the Rome Statute. Of course, you know, the Security Council can refer matters to the court, but this may or may not happen because the Security Council is a political organ. So we cannot depend on the political will of states to refer or not to refer. The only way that we can ensure that the court can act independently is by more ratifications. And even when the Security Council refers a matter to the court, it has affected the perception of these referrals, the fact that some of the countries that are in the Security Council are referring matters to the court while they are not joining the statute themselves. So that has affected also the legitimacy of the institution. So I do hope that in the long term, and maybe not very long, maybe we will all see it, more countries will join and the very powerful will join as well. But I also say that in any event, every country counts. And universality is not just about the powerful joining, although of course they would be more than welcome, but also small countries. Because this court has been created by the small and medium-sized countries, because they are the ones who need the protection of the law more than anybody else. And they are the ones that can change the dynamics on how the world functions by making these institutions more powerful. And small countries count. In September, I will be attending the Forum of the South Pacific Islands. They are extremely small. It's taking place in Samoa. And these are countries that could also help the court by joining the institution. So I think the quest for universality really, we address this to all countries.
Can I just follow up on that? So the argument of countries that haven't yet joined the court, or one of the arguments has been it's great for countries to get together and decide that they want to join the court, but why does everybody have to join? We're all sovereign countries. Why can't we decide that it's wonderful if they want to do this, but, you know, not for us? So that, you know, I don't mean to trivialize the argument, but it's, you know, it's a serious one. And I sometimes wonder whether the ICC, you know, created expectations, going back to your point earlier about raising expectations, that there would be universal membership. And if that in itself makes it more likely that the court will be seen as being selective because it doesn't have jurisdiction over every country. So that's sort of a bit of a puzzle that I wrestle with. With that as sort of a background, I've been intrigued by what I understand your approach to be, which is, rather than say to countries that haven't yet gotten to yes on joining the court, what's wrong with you? Why haven't you joined the court yet? As I understand it, your message has been, I want the court to perform so well that that will persuade you to join the court. Do I understand correctly that that's been part of your message? I wonder if you could say a little bit more about how you try to address the reticence of countries that haven't joined.
Well, first of all, I fully agree that the decision to join or not join a treaty is, by definition, a sovereign decision of each state. And I always try to be extremely cautious and respectful of this, because I think it is the truth. The court is not an organ of the United Nations, it's a treaty. A treaty that has a goal, a global ambition, a global mandate, but still is a treaty. So whether it is or not global at the end of the day will very much depend on individual decisions of states. So all we can do is to all those who believe in the rule of law, in the importance of accountability for the most serious crimes, is try to, first of all, explain why this goal is important, explain how you contribute to this goal by joining the institution. But also you need at the same time not only to explain how important and lofty this goal is, you have to also explain that as an institution, you can deliver in that goal. And that's why I think it's part of the same discussion. I can ask you for your help and your contribution, but at the same time, I have to be accountable. I have to be able to explain that this institution is worth supporting because it can deliver. So, and the same applies to state parties. It is very difficult to ask for cooperation, ask for budget, ask for resources if we don't show any initiative in try to improve governance, in try to improve efficiency. Sure. So I think the debate needs to go together.
Sure, sure. Other questions?
First of all, thank you for coming to DC and speaking here tonight, and then also tomorrow morning at the law school. I wanted to sort of bring back the issue of technology, because I sort of have a similar question, but I want to distinguish between the traditional form of technology that can be provided by a state to cooperate with evidence. But I want to see if you could share your thoughts on the utility of open source intelligence-based atrocity verifications as possibly admissible evidence one day in trial, because I'm sort of part of this growing movement with colleagues at Berkeley and at the Office of the Prosecutor to try to analyze and develop standards for this kind of practice in the future. Thank you.
Well, I cannot give you an answer to that would solve, or I would say, well, this is going to be admissible, this is not going to be admissible, because this is very much in the hands of chambers. I can say, and it is the judges that will need to decide at some point whether certain forms of technology or can indeed be considered admissible, sufficiently reliable and credible. Now, but of course, the first step, and as what I was trying to explain to your colleague, is that the first step is that we understand, and the judges also understand, how these technologies work, and how they can be distorted, or how can they not be distorted, or how they can be interfered. So they need to understand the technology in itself. I have to say that the rules of admission of evidence for the court are extremely flexible. And that is, is a great difference with the common law system, where you have all kind of exclusionary rules. The ICC is very complicated in certain areas. In terms of admission of evidence, is extremely, extremely flexible. So basically, anything could be admitted, provided that the judges are satisfied that it's really reflecting or proving something. So in terms of the law, it would be very easy to admit anything that the judges consider is sufficiently reliable. But the first step is to understand the form of technology.
Can I just ask you to say a little bit more about the technology that you're working on?
Sure. So one of the things that we're doing, is sort of triangulating evidence using, for example, like satellite imagery, videos that are provided online by people on Twitter and Facebook that may or may not be truth. So we sort of look at these videos, we look at the weather of whichever village that an atrocity might have happened, to make sure that, first off, was the weather rainy that day? If AccuWeather says yes, then, and it's sunny in the video, then that's the first red flag. But then looking at whether ruined buildings in a video sort of match what they would have looked like before an aerial strike on Google Maps, and you look at the timing. And you can take it a step further by looking more at the metadata of the information to see if these images were doctored. And you can take a look at that. So there's sort of like basic forms of verification. And in some cases, especially when it comes to international criminal law, and you're trying to use this as evidence, there's more technical aspects to it. So sort of my colleagues at the Human Rights Center at Berkeley are working with the court on the Technology Advisory Board to sort of help with the capacity of that.
Yeah, well, but again, this goes very much to the heart of the problem, is to understand how this form of technology works, what would be the methods of verification that would enable the judges and the parties to understand how can they rely on this type of evidence, and then maybe develop some standards. Yeah, exactly. International standards that would give you some kind of guidelines on what can you expect and how you can verify certain information, and this is extremely important because indeed we are dealing with extremely complex crimes that are very difficult also to gather evidence in a traditional way, because sometimes you have to go into areas that are on ongoing violence. So you cannot just go and try to prove your crimes in a way that you would just go around with domestic and individual acts. So, and this is a question also, for instance, how much the not only new technologies, how much can the court rely on reports from other entities, reports from the United Nations, for instance, reports from peacekeeping missions that are in the field at the time of the event. So this is a debate that is not totally solved at the court, how much they can rely on all this information. Because if you go about proving these crimes just with witnesses that come and then they're examined and cross-examined, then it takes forever, and that's not a good solution for expediting. But in addition to expeditiousness, this is not really the answer when you're talking about massive crimes that affect a lot of localities with a lot of victims and perpetrators.
And I know you had a question. I'm going to try to get the mic to you in a second, but I wanted to just, following up on that, say that, you know, if all the issues you mentioned can be worked out, it seems that one advantage to the kind of technology you're describing is that it may reduce the burden on vulnerable witnesses, and witness protection is one of the perennial huge challenges for the International Criminal Court. I don't know that you can ever have a trial without direct witnesses, but to the extent that technology improves and the admissibility issues and reliability issues get sorted out, that could be one advantage. Not that, the technology you're describing doesn't also put people at risk. That's, I'm sure, an issue that you all are focusing on. Down the road, it seems that it may also have the advantage of being the kind of evidence you could share with domestic jurisdictions without raising the kind of concerns about putting vulnerable witnesses or confidential witnesses at risk. So it's an important, potential new direction. I can't see your, Ms. Esbrook, is that your name? You had a question earlier. Thank you for your patience.
Yes, no problem. Okay, so my question is about aggression. You mentioned Kampala, that was 7 years ago. And in Kampala, states parties said in 7 years, if 30 states parties ratify, we can expand our jurisdiction to cover aggression. We're in 2017, 30 states parties have ratified, 30 plus. And this sort of seems to be an issue that's largely flown under the radar. There have been a couple articles about it, but not much. And I'm just wondering, broadly speaking, has the court been preparing for what I think there's a prevailing consensus it will have its jurisdiction expanded? How has the court been preparing for it, if at all? And how do you think internationally the court's perception may change once aggression comes into play?
Thank you very much for this question that is very timely, because indeed this is 2017. So this is the year where the Assembly of State Parties will need to discuss in this assembly that is going to take place, I think, the last week of November or first week of December in New York. One of the issues to be discussed is whether states trigger or not the jurisdiction of the court with relation to aggression, because the number of required ratifications have been attained. So now the debate needs to take place. It is unclear what is going to happen. This is a highly contentious issue. There are different views on this. The court has expressed the position that the position of the court is that the court has no position. Because it's really a debate among states on whether they want to trigger or not the jurisdiction. So what is the court doing in light of this situation? What we are doing at this point, because we don't know if this is going to be triggered or not, is to at least start ensuring that the court knows what is the provision about. And we are going to have an information session, I think, very soon. I think it's in June as well. That I don't remember the exact date, but very soon in the coming weeks. We're going to have an information session on aggression intended to the judges and other organs of the court. We have invited 3 academics to come and explain what is, and individuals that have been involved in particular in the discussions on aggression. So to make sure that all judges and everybody else at the Office of the Prosecutor and elsewhere understands the provision, and maybe already start a discussion on what type of rules would be needed if indeed the crime on aggression is triggered, the jurisdiction on the crime. For instance, the provision on aggression already indicates that if there is a situation on aggression that is brought before the court, the entire pretrial division will need to authorize the investigation. So already there you have something new that will need to be looked at to see whether we need an additional rule or regulation. But first step is to understand this provision, which is extremely convoluted, and we take it from there. But I think the issue of whether we will be triggered or not is very much in the hands of states.
Other questions? Yes. Yes. I'm sorry, I don't know your name.
Thank you. My name is Sarah Crisatelli, and I was part of the U.S. negotiating team. And this is probably an unfair question that you can't answer, but is there anything that you think now we could have done better or differently in Rome? I mean, I have a list. But
That was exactly the question I was going to ask if you didn't raise your hand.
I'm glad that there is someone in this room that is also to be blamed.
Thought you might need a little solidarity.
I'm fine with it.
Well, actually, I've been asked this question before, and I have always refused to say that we did something wrong. Not because I think it's perfect. I think some of the ideas there are very good. I think the idea, the basic idea that the court had to combine legal systems of the world and legal traditions, and it could not be identified with one system of the world, I think it is still an idea that I defend very much. I don't think it would be acceptable that we have an international court, a global court that reflects the common law system or the civil law system primarily. So I think this great effort to mix provisions and try to have a combination of what we thought at the time could be a workable scheme, still a very good one. The system is extremely complicated because also in certain areas, also there was not only the conflict between systems, but there was this tension between those who thought that we needed a very detailed scheme for the judges and the court, and those who wanted to have very just general principles and trust the court that would do the job. So we are a little bit in between, and that has created problems. In some cases, there is too much detail, and I hope and I wish we had not put so much detail that now is unworkable. And in other cases, the situations are very ambiguous, the answers. And that has also created a lot of confusion, and I wish we had been more concrete there. So I probably, if we were sitting around the table today, we would come with very much something similar. I think the pre-trial phase is an area that is very innovative and extremely complicated. And maybe there it would have been better to make sure that we streamline the process in a better way, make sure that the judges understand from day one, and also the prosecution, that that the proceedings are one continuing exercise and not different phases. Because what we had in the first years of the court is that the pre-trial would spend months or even years trying to come with some kind of solution, and then the trial judges would simply ignore completely what had been done in pre-trial and relitigate the entire thing. So it would have been good to have some clarity there, and maybe to avoid certain issues, in my humble view, in pre-trial, that opens the door for some temptation of a mini trial before the trial. So I think now we have reached a good solution, but it took some years for this to be understood. I have to say that the proceedings themselves, well, we don't have the concept of indictment, we have charges. So I think we try to avoid using terms that had a connotation in systems, but then by avoiding concepts, maybe we should have clarified the system better. But all in all, I think the system is workable, provided that we get together and understand what is best for the system. The issue of admission of evidence is still very complex because it gives a lot of freedom, but maybe not enough clarity, and some concepts are being understood very differently depending on where you come from, a common law or civil law system. We are still fighting among ourselves, what is admission of evidence? Do we need to admit every piece of evidence or not? This is something that is an ongoing discussion. So maybe we should have been more clear, but I don't know if we knew whether that would be the best solution. And I think the fact that we are disputing this today is because maybe we need the experience to see what is best. The structure of the court is complicated. But again, this is something that is also inherited from other tribunals. This these three organs, that one is a principal administrative officer of the court, but is under the authority of the president, who has the entire court except for the prosecutor that is independent. Well, the entire structure is almost a miracle that it works. And I think it had a lot of problems at the beginning, because it really it depends very much also on the goodwill of individuals in charge, and that is something that I'm trying to do. And I'm very privileged, because I am working with a registrar and a prosecutor with whom we get along, and we can discuss things very openly and together. But we need to establish certain mechanisms for the future, for the cases in which maybe individuals will not get along so well. So you cannot have an institution that depends on the goodwill of the persons in charge only. And another part of the court that is extremely complicated is the relation with the Assembly of State Parties. Do you have an Assembly of State Parties that, of course, that needs to decide on the budget and other matters, but at the same time has always this tendency to micromanage the court to the point that it could be damaging for an independence of the institution. So these are areas that I don't know if we got it wrong, but maybe it would have been better to clarify. But I don't know, maybe you have the answer of what you would have done better.
My mistakes.
Why don't you go ahead? Yes, sir, sorry.
Hi, I'm Jeremy Lasley. Thanks a lot for this very interesting discussion. My question today deals with how the court or, say, the prosecutor could deal with emerging or current conflicts. So as you mentioned earlier today, a lot of the cases that the ICC deals with will actually be tried years later. And I think people are well aware of this, but in a way, the ICC could also have an impact on some current conflicts, even through non-prosecutorial methods. And so I'm thinking, of course, of conflicts like Yemen or Syria. But my question is, what types of non-prosecutorial methods, or what types of methods simply would the ICC have in dealing with cases that have not matured yet, or in monitoring some of these cases? Thank you.
I was reading some comments that were made, I think by David Sheffer, in a presentation where he said that the court is there to provide justice and should not be trying to deter violence, or something like that. So I wonder what he would have answered to your question. But I think we need to remember that the court is a court, and that the prosecutor, that is a hugely important. She's the one now who has the impossible job. She needs to decide where to investigate, who to prosecute. Now, one question that is there is, before opening an investigation, should she be saying, addressing issues of violence in a situation without opening an investigation? And for instance, we see the High Commissioner for Human Rights and other organizations, they do make declarations about the situation. They ask them to be cautious. They warn them of things that could happen. So the question is, to what extent should the prosecutor join in this type of non-investigative declarations? And I think that is your question, maybe. Could the court start saying, oh, be careful, if you continue like this, we will open an investigation and we'll bring you here to the Hague. I think that there might be some room for that, but my view of this is that the best contribution from the court is to do its own mandate. And that it's not good for a court to be perceived as a political actor. And that is the risk that the court has if it starts making declarations in the abstract. The court is there to investigate and prosecute. Declarations in the abstract, although it may be tempting, because sometimes you feel that maybe if you say something, then something may happen. I think the court needs to be extremely cautious. The court has said certain things sometimes, but my view is that we need to accept that the court has a hugely important mandate, but it's a narrow one. And you need to protect this mandate, and by not becoming political before, or never, you can never be political, but you risk being perceived as political if you start talking too much before you have a case or before you have an investigation. Also, you have to remember that investigations, when they are decided proprio motu by the prosecutor, need to be authorized by the judges. So also, it is also we need to respect this division of labor, I would say, within the court, to make sure that you don't have a prosecutor saying all kind of things on one side, and then these investigations, if they happen, they are not even authorized by the judges. So I am a little bit conservative there.
Can I ask you a question that's not a follow-on to that one, goes in a somewhat different direction? So from time to time, there's talk about the ICC having proceedings in the country where the crimes occurred so that justice is closer to the victims and more real to them. How feasible is that really? I mean, is that something the ICC could imagine doing if it had infinite resources, the kind that would be required to prepare a local site for all of the security that would be necessary? Why doesn't it happen more? Would it make a big difference to have proceedings in the country?
Well, the court has tried to do this in several cases, and including in some of the recent cases. I don't think it's realistic to think that the court can have the entire proceedings in the situation country, because the technology that is required, everything would be extremely expensive. We need to build the courtroom in the place. But we have attempted to have at least part of the proceedings, or maybe even the start of the trial in the country. The thing is that in order to have, of course, if you do it, it's a way of outreach, or is in order to get closer to the victims and the local communities that were affected by the crimes. So if you go there, you really have to go into the localities where the things happened, and it would not be sufficient to just simply go to the capital of the country, unless the capital is concerned. So we tried in the past, and we were confronted to huge security concerns. It is expensive, but the main problem was in one case that we needed to finally desist from doing that. It was really security concerns. In order to do this, we had it was not security for the court itself, but for the victims and the people that would be lining up to come into the courtroom. And at the time, we made an assessment with a peacekeeping mission that was going to support us to do this. And the only way to have the in situ proceedings was to almost hiding in order to protect the victims. So what was the point if they could not come and be close to everything? And in the same occasion, say, well, maybe if you come, but you could not bring the accused, because that was also a huge security concern in that particular case. So, well, basically, it was not happen. It could not happen. That doesn't mean it will not happen in other cases. We have to see case by case, but I think we all recognize that it will be beneficial. One thing that we could do in the meantime, even if we don't have proceedings, is to have at least in situ on-site visits. We had one in Katanga, where there was a visit to the locality by the judges and the parties, and we could foresee something similar in another case in the court. That is much easier to do, And also it's a way of, well, first of all, for the judges and in particular the judges to get acquainted to the place that where the crimes were committed. And the second one is to be closer and be seen by the local communities.
Yeah.
So that I think you can expect to happen in your lifetime.
Right. Great. No, that sounds really important, the last point you made, because again, drawing on the ICTY experience, I'm pointing to Matthias Hellman because he was an outreach officer for the ICTY in Bosnia before he came to the ICC. One of the things that's sort of elusive but very important to survivors was just having a sense that the ICTY recognized them as mattering. And so it was beyond all the sort of specific points of information that they got or didn't get from the ICTY, or clarification of judgments, or whether the judgments were translated into the local language. Beyond all that, there was just this kind of message that the tribunal either cared or didn't care about them. And it's sort of hard to capture that, but I think those on-site visits that you described kind of do that. They convey that message.
Well, very much so, and I'm glad you mentioned Matthias, who has this experience from the ICTY experience. So talking about lessons learned, see, we bring the lessons through the people. Now, in addition to on-site visits and or proceedings in the place, I have to say that we are also trying to upgrade and improve the presence of the court on a permanent basis through field offices. Mm-hmm. And we have field offices, for instance, in Uganda, we just upgraded the field office. It's a bigger office with a more senior person there. So because we think that also the permanent presence of representation from the court is extremely important for outreach purposes, but also for the court proceedings more broadly. And actually many of the for instance, we have a lot of testimonies through video link talking about technology, and this takes place in the field office, and the field office is also on a permanent basis doing outreach sessions, going to the localities, talking to the diplomatic community, to local NGOs. So that is also a way of ensuring visibility of the court in situation countries.
Mm-hmm. Mm-hmm. Any other questions? Okay, I think we've imposed enough time.
I like this.
I don't know when you arrived, but I am worried about approaching the limits of jet lag. So I want to thank you for an extraordinary evening. This was fascinating. Thank you so much.